It's a real privilege to be here with you today, and to be amongst leading tax law scholars crossing the bridge to human rights. My colleague McGill and I from the Center for Economic and Social Rights are here very much from the other side of the bridge, from the human rights community. We like to think of ourselves as straddling the fields of scholarship and advocacy, but the Center for Economic and Social Rights is very much an advocacy organization that does apply research to challenge some of the biggest injustices that we see in the field of economic and social policy. So as has been said, as John mentioned in his opening remarks, we see that tax is central to human rights in at least three critical ways. Tax is probably the primary means of generating the resources that are necessary for realizing human rights, particularly economic, social, and cultural rights, which are in some ways more resource dependent. But they're also a critical policy instrument for tackling inequality and redressing disparities in rights enjoyment, as well as being at the core of measures needed to create responsive and accountable systems of governance. So for those three reasons, taxation is and must be seen as a critical human rights issue. And yet it is relatively new on the human rights agenda. As resources for social spending come increasingly under attack as a result of fiscal austerity policies which are being driven across the globe, not just in Europe and North America, and as patterns of income inequality and wealth concentration revert back to the 19th century, there is clearly an urgent need to bolster the resourcing, redistributive, and accountability functions of taxation. We at CSR have been working to try and bring taxation under the lens of human rights scrutiny in very different contexts, from trying to expose how unfair tax policies in Guatemala lead to stunted human rights and development outcomes, to addressing the unfairness and injustice of austerity measures in countries such as Spain and Ireland, or indeed now in the context of the post-2015 sustainable development debates, trying to inject concrete policy proposals around fiscal policy reform at the international level. These are just some of the contexts in which we've been addressing tax from a human rights perspective, highlighting the human rights impacts of inadequate, inequitable, and unaccountable tax policies at both the domestic and global level. So I want to share some thoughts on what we feel from our experience human rights can bring to the struggle for tax justice, and also share some insights as to challenges and opportunities that we face for collaboration across fields of discipline. In terms of what can human rights concretely bring to this task, I think human rights offer two basic things: a set of internationally agreed normative principles in which we can ground claims for tax justice, and secondly, some additional avenues for accountability through which unfair tax policy and tax abuses can be challenged nationally and internationally. So on this first point, the normative principles, what are these normative principles and where are they set down? Well, it's interesting to see, to reflect that the linkage between tax and human rights in terms of international standards is nothing new. More than 300 years ago, the French Declaration on the Rights of Man and of the Citizen spoke of the right of citizens to decide on matters of taxation and to know to what uses taxation is put. More recently, however, the international human rights regime, the modern infrastructure, if you like, of human rights protection, does not mention taxation explicitly. For example, there's no reference to taxation in the Universal Declaration of Human Rights, the cornerstone of the modern human rights framework. But the obligations of states with regard to their use of resources is addressed directly and very pertinently in the International Covenant on Economic, Social, and Cultural Rights, which, as many of you will know, is one of the two core international treaties that in which the provisions of the Universal Declaration were codified in a binding treaty. The covenant, which the vast majority of states have signed up to and ratified, contains some fundamental provisions of potentially enormous significance for tax policy. Article 2.1 of the Covenant places an obligation on all states party to the Covenant, to use the maximum of their available resources to achieve progressively the full realization of economic, social, and cultural rights. In fact, the formulation is even more clumsy than I just read out. But despite its very ungainly phrasing, this potentially should be a normative instrument that we can use to make this a fundamental tenet of fiscal policy making. The Committee on Economic, Social and Cultural Rights, which is the UN expert body which monitors compliance by states parties with the covenant, has elucidated the content of this principle of progressive realization, as we refer to it as, over the last 15 to 20 years. I'm not going to go into detail about this principle, but just to stress that the committee has affirmed that even in times of resource constraints, all states have a duty to generate and allocate resources in such a way as to move as swiftly as possible towards the goal of fully realizing economic, social, and cultural rights. They also have an immediate duty not to adopt retrogressive fiscal measures or any retrogressive measure which may result in deliberate backsliding on human rights enjoyment. There's also an immediate obligation to ensure no discrimination, which applies to the generation and allocation of resources, and an obligation to prioritize states' core obligations, which are defined in more detail in the covenant and in the general comments of the committee. All states have duties of international cooperation, which include of extraterritorial obligations that apply across borders, to ensure their policies and practices do not harm the realization of human rights in other countries. And that applies to fiscal policy too. So these provisions are complemented and bolstered by soft law provisions, by provisions from other instruments which are not binding treaties, but nevertheless have great authority. Three soft law instruments in particular merit mention here for their direct relevance to taxation. The Maastricht Principles on Extraterritorial Obligations, which were approved just recently in relation to economic, social and cultural rights, are particularly useful for their analysis of international cooperation in tax matters, which they do explicitly, including with respect to the need for exchange of information to confront tax abuses and the need to avoid secrecy jurisdictions. A second soft law instrument, also recently adopted, is the Guiding Principles for Business and Human Rights, which set out a useful framework, the Respect, Protect and Remedy framework, with regard to the obligations of business to respect human rights and the obligations of states to ensure, to regulate and ensure that corporations do not harm human rights. Thirdly, the Guiding Principles on Extreme Poverty and Human Rights, which the previous Special Rapporteur on Extreme Poverty and Human Rights was very active in leading on, explicitly references that tax policy must take into account states' human rights obligations, and that states have an obligation to take steps to reform their tax policies for the purposes of poverty reduction. I could go on in terms of canvassing the normative framework of applicable human rights law and standards for taxation. But the point that I want to stress is that as principles set down in international treaties which have been ratified by the majority of states, these human rights standards provide a potentially powerful normative reference point for advocating for more just and effective taxation systems at both the national and global level. And as Alison has argued in her work, these standards also provide a vocabulary which can help to shift dominant tax policy discourse. For example, this duty to devote maximum available resources to progressive realization of human rights. You could argue that this gives legal force to the imperative to tax, as well as articulating what is the ultimate goal of tax policy. The principles of equality and non-discrimination, so clearly articulated in a range of international human rights standards, can act as a much-needed corrective to the long-standing tendency in traditional tax discourse to privilege the pursuit of efficiency over that of equity and fairness. And the duty of states to cooperate in the realization of human rights beyond their borders can also provide a useful counterpoint to the notion of tax sovereignty, which has hampered effective action against the transnational impacts of tax evasion and harmful tax competition. So, on to the second point around the avenues for accountability that human rights offers. human rights are not just a body of norms, but an infrastructure of accountability to give effect to these norms, through which claims against tax injustice can be actioned. And CSR has tried to operationalize these norms in concrete settings and bring claims and bring cases and analysis to a number of human rights bodies at the international and regional level. I don't have time in my remaining minutes to outline them all, but I want to stress the relevance here of the treaty bodies, the UN treaty bodies, these expert bodies that monitor compliance with the international standards that I mentioned. CSR, for example, has pushed the Committee on Economic, Social and Cultural Rights to further clarify and apply in concrete settings the principle of non-retrogression, the principle of no deliberate backsliding. And we did so in the case of Spain, where we put together with a coalition of activists in Spain a shadow report documenting the human rights impacts of unfair austerity policies in the wake of the economic crisis. And we took this analysis to the committee and argued that Spain's fiscal policies were indeed retrogressive. We built the evidence, built the argument. As a result, the committee was pushed much further than it would have felt comfortable otherwise, because it had the documentary evidence in front of it, to make a very strong pronouncement about the principle of non-retrogression, not only in the case of Spain, but by sending a letter to all states party to the covenant, outlining that those states which are considering taking fiscal austerity measures must avoid retrogression by demonstrating that they carefully considered all more equitable alternatives, including fair revenue-raising policies and tax measures to support social transfers and to mitigate inequalities that can grow in times of crisis. So this is an example of how advocacy and well-documented research can help not only to elucidate the content of these norms, but also to nudge accountability mechanisms to apply them in concrete situations. We're also now undertaking a similar project in Egypt with another accountability mechanism at the international level, the Universal Periodic Review. This is a mechanism of the UN Human Rights Council. It's not an expert review process, it's a peer review process, so governments effectively reviewing each other with all the problems that entails. But it is a process that allows for significant civil society input. And so with our partners in Egypt, tax justice advocates and human rights advocates in Egypt, we have similarly put together a shadow report documenting how fiscal policy in the context of Egypt's transition has basically further disadvantaged the poor and fueled inequalities that were persistent since the Mubarak era. I also want to stress, while we're talking about UN human rights mechanisms, the role of special rapporteurs, and Anna Tate is here, and will speak to the work of the special rapporteur on extreme poverty in more detail. Special rapporteurs are not really adjudicating mechanisms, but the special rapporteurs are independent experts of the UN system, whose role is particularly useful in further clarifying the application of these somewhat airy and abstract human rights norms. They do undertake country visits and country investigations, as some of them have some form of complaint mechanism. And I just want to note that in addition to the work of the Special Rapporteur on Extreme Poverty, many other Special Rapporteurs are beginning to address in concrete settings the impacts of unfair taxation on the human rights concerns within their remit. But really the Special Rapporteur on Extreme Poverty deserves, and I don't want to speak to Kate's area, but deserves really special mention in the groundbreaking nature of the report that has just come out, which looks in a comprehensive manner at the connections between tax and human rights obligations. Okay. I also want to stress, and I know I need to finish it, that accountability is really much more enforceable at the national level. And again, human rights avenues for accountability to be explored, that CSR and others are exploring, include the possibility of invoking human rights provisions of national constitutions. So constitutional court challenges to unfair tax policy. And there are there is emerging case law and jurisprudence, some interesting case law, for example, in Portugal in the context of austerity measures there. CSR is trying to put together a more systematic analysis of austerity mitigation, including how fiscal policy issues have been handled. And that is an area for potential collaboration with the tax law research community. We're also focusing on the role of national human rights commissions, national human rights institutions, which we feel could be playing a much more active role as kind of bridging institutions across institutions that can nudge other institutions of government into playing their supervisory role more effectively. And in the European context, a number of national human rights commissions have begun to come out against tax injustice. To conclude, some insights from this work. We have seen concretely how tax advocacy from a human rights perspective can help shift the discourse in a way that bypasses some of the ideological minefield around taxation. And we saw this very clearly in Guatemala. It must be said, however, that adjudication bodies, courts, human rights monitoring and oversight mechanisms are often reluctant to weigh in on what they see as the politically contentious issue of fiscal policy. And in order to overcome that reluctance, we as advocates must develop more effective tools to make the causal link between tax collection and between taxation and human rights abuse. It does require methodological tools that are outside the toolkit of the traditional human rights advocacy. And I don't have time to explain what we would propose to do in that sphere, but I hope in the discussion we can talk about how concrete possibilities for collaboration to develop that toolkit more effectively. Thank you.